Seated. Good morning. This is cause number DA 230225, Montana Environmental Information Center versus Department of Environmental Quality in Northwestern. Time for the oral argument. Are counsel ready to proceed? I guess Ms. Harbine, you're first up. Oh yeah, I got this backwards. I apologize. It's Mr. Langston.
Good morning, and may it please the court. I'm Jeremiah Langston, appearing on behalf of Defendant Appellant, Cross-Appellee, Montana Department of Environmental Quality. I'll be arguing for 15 minutes in my opening and reserving 5 minutes in rebuttal. DEQ requests that this court uphold the district court's findings that DEQ adequately addressed noise impacts under MEPA. DEQ additionally requests this court reaffirm its finding in Water for Flathead's Future that the remedial framework found in section 75.1.201, subsection 6C, which I'll be referring to as subsection 6C for the remainder of the argument, applies to the remedy of vacatur. DEQ takes no position on greenhouse gas impacts or visual impacts. Turning to the first subject of noise impacts, the district court found that DEQ had adequately addressed this issue by identifying potential noise impacts, identifying potentially impacted residences in other areas, and conducting far-field noise estimates. This analysis complies with ARM 17.4.608 subsection 1A, wherein DEQ is required to discuss the severity, duration, geographic extent, and frequency of impacts. As we explained on page 16 of our combined reply-response brief, DEQ satisfied all of these requirements. In this litigation, MEIC ignores DEQ's analysis when it claims that DEQ did not evaluate the extent, severity, or duration of noise impacts. As this court said in Water for Flathead's Future and reaffirmed in Montana Trout Unlimited, courts must credit the entirety of the agency's analysis. Without engaging in the entirety of DEQ's analysis, MEIC's arguments fail under these cases. MEIC in litigation also attempts to move the goalposts. For instance, MEIC contends that DEQ should have conducted more far-field noise tests. But MEIC never made such a request in its public comments during the MEPA process. It asked DEQ to evaluate, quote, the impacts of construction and operations related to noise, including an analysis of any applicable noise regulation, end quote. Nowhere in this request did they assert that DEQ needed to conduct far-field noise estimates. This is similar to this court's analysis on Montana Trout Unlimited, wherein environmental plaintiffs in that case contended that DEQ failed to provide sufficient specifications for how thick the layers of surface cemented tailing should be. This court rejected that argument, finding, quote, MTU points to nowhere in its comments that it suggested DEQ must put specific parameters on the level of thickness of the lifts. What's more, in Belk, this court found that DEQ's analysis discussing the distance between the lake and the permit and how this will affect noise effects was sufficient to meet its hard look requirement. With Belk as a measuring stick, DEQ has satisfied its obligations under MEPA for noise impacts. What's more, MEIC complains about DEQ's cumulative impacts analysis, and they provide an analogy of several fans running in a room. To begin with, this analogy is flawed because the project won't be located in a room. What's more, this amounts to counsel testifying about matters outside the record. But even aside from that, there are fundamental problems with the standards which they employ. For instance, in Montana Trout Unlimited, this court said that the substantial evidence standard is the appropriate standard in challenging DEQ's conclusions. MEIC has not engaged this standard, and their argument should fail. What's more, in Montana Trout Unlimited, this court said that courts should not substitute their own judgment for that of the agency by asking whether the agency's decision was the correct one, scientifically, morally, or politically. Essentially, what MEIC is requesting this court do is second-guess DEQ's analysis and comment and arrive at alternative conclusions. This exceeds the procedural nature of MEPA, and this court should reject such arguments. I want to now turn to MEPA's remedy provisions. DEQ's argument on this subject is simple. Under subsection 6C, the district court must make specific findings before granting other equitable relief. Vacature is other equitable relief. Therefore, a district court must make specific findings before vacating a permit under MEPA. MEIC makes a number of tortured arguments in an effort to claim that vacature does not constitute other equitable relief as contemplated by subsection 6C, all of which should be rejected. Most fundamentally, MEIC's argument fails because it overlooks the fact that remedies for MEPA violations are exclusively provided by subsection 6C. If vacature escapes subsection 6C, then vacature is altogether unavailable for MEPA violations. In briefing, MEIC only provides a tepid footnote in responding to DEQ's argument on this point, wherein it claims that this exclusive language found in subsection 6C only applies to the injunctive remedies that could be authorized under MEPA. But this is in direct contrast to the relevant statutory text, which states, quote, "The remedies provided in this section for successful challenges to a decision of the agency or the adequacy of the statement are exclusive," end quote. Thus, MEIC's arguments are in direct contradiction of plain statutory text, and they should be rejected. This subsection 6C's exclusive remedies language was also an animating feature in this court's decision in Water for Flathead's Future, wherein it overturned a district court's finding that it had implied power to vacate a permit. Thus, this fatal flaw in MEIC's reasoning should be decisive to this issue. And it's important to note that this court went out of its way in Water for Flathead's Future to explain that district courts cannot ignore the plain text of subsection 6C for remedying MEPA violations. MEIC provides substantially the same arguments as it did as the environmental plaintiffs in that case. This court should accordingly stay the course and maintain its existing analysis from that case. In conclusion, DEQ requests that the court affirm the district court's conclusion that DEQ adequately addressed noise impacts and reaffirm its finding in Water for Flathead's Future, finding that district courts must adhere to 75-1-201 subsection 6C in providing MEPA remedies.
Mr. Langston, before you sit down, I have a couple of questions about what you're not addressing. Just to clear a couple things up for me, it's mentioned in the briefing that DEQ, after the district court's decision, started a new EA evaluation on the lighting issue. What's the status of that? Was it withdrawn after the stay, or what's happening with that?
Your Honor, the status of that supplemental EA is on hold, and it isn't just related to lighting impacts. So I think the court is well aware that after the district court, in this case, issued its decision on greenhouse gas impacts, the Montana legislature amended 75-1-201 subsection 2A in HB 971. And DEQ in that supplemental EA intended to conduct the new analysis for greenhouse gases under that law. And it's notable that there are different exceptions for when DEQ can conduct greenhouse gas analysis in the new HB 971 law. So it's different than the 2011 version of the law.
And it just
Go ahead.
well, just to follow up on that, there's a, I guess, one, can you address this is two questions, so I'll keep it brief. One, do you want to say anything about Northwestern's Notice of Supplemental Authority and the new federal regulation? That's part one.
In response to that, Your Honor, DEQ took no position on that Notice of Supplemental Authority. You know, I think it relates to their Bitterrooters argument. DEQ notes that we get a lot of questions about that case, and I think some clarification on its confines would be helpful to the agency, but DEQ, as a general matter, doesn't take a position on any of the issues related to greenhouse gases in this appeal.
Okay, well, sorry to put you on the spot again, but in the appellee's brief, they say that the Clean Air Act already authorizes DEQ to establish emission limits from any source necessary to prevent, abate, or control air pollution, and such limits may be more stringent than federal requirements, citing 75-2031 and 4. Do you agree with their characterization of that statute?
Your Honor, my recollection of this issue, as it's been brought up in this litigation, was in relation to the best available control technology and whether or not DEQ could engage in an analysis on that subject. It's DEQ's view that that's not particularly relevant to whether or not DEQ is authorized to engage in MEPA analysis for this particular project. So,
Okay. Thank you.
But I did want to finish up just on the status of DEQ supplemental EA.
Okay.
This new law was passed. DEQ was ready to conduct the supplemental EA after we had filed opening briefs in this case, but before we completed the supplemental EA, the district court issued its decision and held, which invalidated the relevant provisions of HB 971, and thus DEQ's plan to go forward with conducting the supplemental EA was essentially short-circuited because of that decision.
Okay. So you're waiting on held then?
Yes, Your Honor. And that brings me to two final concluding things. DEQ is not conceding that there are any MEPA violations in this appeal, but if this court does find that there are MEPA violations in this case, it would request two things on remedy. First, it would request that the matter be remanded without vacature because MEIC waived its right to request vacature pursuant to subsection 6C. Alternatively, this court could provide concurrent jurisdiction to both DEQ and the district court, DEQ to conduct the additional MEPA analysis and the district court to make the requisite findings. Second, it would be immensely helpful to DEQ to know what laws apply to its MEPA analysis for a project. I assume the court will manage its docket in a rational and reasonable way, but if the courts could somehow issue its decision at the same time as held or tie the two cases together so that DEQ knows whether or not to apply HB 971, it would be very helpful to the agency. And with that, I'll reserve the remainder of my time. Thank you.
Thank you.
Good morning. May it please the court. My name is Shannon Heim. I am General Counsel and Vice President at Northwestern Energy. My portion of the argument this morning will focus on the practicalities of the project and the key precedent of Bitterrooters for planning versus DEQ. I am not planning on delving too deeply into lighting unless the court has specific questions about it. I'd like to reserve 5 minutes for rebuttal. The Laurel Generating Station is designed to fill in when the intermittent renewables in our system, solar, wind, hydropower, either cannot or do not perform. The Laurel project provides critical reliability for our customers and for our system. Each of the 18 engines that make up the Laurel project operate independently or together collectively and can go from a cold start to full load in 8 minutes or less, which provide us an incredible amount of flexibility to meet our needs and the needs of the system. Air quality permits are dense, technology-driven exercises. As a utility building a project, we go into that process knowing what pollutants are regulated, how they're regulated, and what information our regulator needs in order to process the air permit. We design a facility knowing what we need, what the grid needs, and how we meet the needs of the environment. The Montana Clean Air Act contains the substantive permitting requirements to obtain an air quality permit, while MEPA provides the procedural requirements governing DEQ's review and collection of information needed for that substantive review. Both played an important role in DEQ's analysis of Northwestern's air permit application. But Bitterrooters tells us that DEQ did not make an error in declining to discuss the GHG emissions of Laurel deeply in detail in the EA. This is because greenhouse gas emissions are not regulated for a facility like Laurel, and greenhouse gas information could not affect DEQ's ultimate permitting decision. I'd like to discuss Bitterrooters in a little more detail. Bitterrooters holds that a close causal relationship must exist between the environmental effect, greenhouse gases in this case, and the agency's legal authority in order to trigger a MEPA analysis of that effect. An agency is a legal cause of an environmental effect only if it can prevent that effect through the legal exercise of that independent authority. In this case, that independent authority is grounded in the Montana Clean Air Act. To phrase it differently, an agency is not required to perform a MEPA review of environmental effects. It cannot lawfully prevent or regulate if it cannot lawfully prevent or regulate that environmental effect. Therefore, a permit cannot be conditioned or denied upon failure to perform such a review.
So can you address the appellee's argument that Bitterrooters and Public Citizen, the other cases that it cites, are different because, as we said in Bitterrooters, it was like the tail wagging the dog because the impact in that case, the subdivision was under local authority, and here the air quality permit is the dog. In other words, there would be, without the air quality permit, that's what considers all the pollutants, and that greenhouse gases are rolled into that.
Yes, plaintiffs focus on the facts instead of the legal holding. The legal holding of Bitterrooters is what we need to focus on, and the legal analysis is what does the substantive statute give the agency permission, authority, legal authority to regulate. And in Bitterrooters, it is the same as here. The underlying statute, the Montana Clean Air Act, does not give the agency authority to regulate greenhouse gas emissions. And so, as in Bitterrooters, if it cannot condition the permit on the emission of greenhouse gases, it cannot deny that permit, consistent with Bitterrooters. And so, therefore, a MEPA analysis cannot be the basis to deny or condition that permit. So we frankly believe that plaintiff's argument is just wrong, that it is similar to the but-for cause analysis that was rejected in Bitterrooters by this court and by the United States Supreme Court in Public Citizen. In this case, it can't be seriously disputed that at all relevant times, DEQ did not have the lawful authority to regulate or prevent the emission of greenhouse gases under the Montana Clean Air Act. At the time Northwestern applied for its permit, neither the EPA nor DEQ regulated greenhouse gases. That remains true today for Laurel. As Northwestern documented in its Notice of Supplemental Authority on May 9th, EPA recently promulgated new greenhouse gas emissions for coal plants and some natural gas plants. It is notable that projects like Laurel are exempt from those regulations, due both to its size, it's relatively small in the grand scheme of things, and on the basis of the technology it employs. Because DEQ did not have lawful authority to prevent or regulate greenhouse gas emissions for Laurel, DEQ was not required under Bitterrooters to perform a MEPA review for emissions of greenhouse gases for the Laurel project. Bitterrooters limits the ability of MEPA to expand the scope of the substantive statute, here the Montana Clean Air Act. 75.1.102.3b of the Montana Code annotated provides no additional regulatory authority to an agency and does not affect an agency's specific statutory duties to comply with environmental quality standards. MEPA must be construed in harmony with the substantive limitations of an agency's applicable regulatory authority. The MEIC in this case asked the court to revoke the Laurel air quality permit based on DEQ's failure to analyze impacts beyond the scope of the Montana Clean Air Act. Effectively, MEIC is using MEPA to expand the scope of the Clean Air Act. We believe that that is contrary to the plain text of MEPA and this court's precedent. We think that argument is inappropriate, and we ask the court to reject it. I would like to address a couple of the arguments that plaintiffs have offered to circumvent the plain language and intent of Bitterrooters. Plaintiffs argue that they should win under a Bitterrooters analysis, reasoning that DEQ is the cause of the plant, or the cause of the plant's greenhouse gas emissions because they could lawfully prevent the emissions simply by denying the permit. We believe that this is another iteration of the but-for argument that this court rejected in Bitterrooters and the United States Supreme Court rejected in Public Citizen. The DEQ could not, in the exercise of its lawful authority, deny the permit based on greenhouse gas emissions because there are no legal standards for greenhouse gas emissions. In this case, in granting the permit, DEQ verified that the plant will comply with emission standards for all pollutants regulated under the Montana Clean Air Act. There are 5 or 6 very specific pollutants that have established through regulatory process emission standards. Everything has worked as required. They are not challenged by plaintiffs. It is important to note that they have not challenged any of the substantive rules or application by the department. Only a MEPA challenge was brought for a regulation that does not exist. Any decision to deny the permit based on greenhouse gas emissions would be arbitrary and capricious and arguably deny or violate Northwestern's due process rights because it would require DEQ to develop regulations on the fly during the application process and then apply them to Northwestern sua sponte during the application. I would like to note that Northwestern does join DEQ's request that the court reaffirm its holding in Water for Flathead's future and not vacate the Laurel air quality permit during any remand. We absolutely do not believe that remand is appropriate. We do not concede any issues, including lighting, but if the court disagrees, we absolutely believe that plaintiffs have waived any argument. They made a strategic decision not to seek any equitable remedies. And at this point, we believe they do not get a second bite at that apple. So our permit should be reinstated and hold if there is a remand. Northwestern requests that the court reverse the district court and reinstate our air quality permit. At this point, I will reserve the rest of my time.
One final question. Northwestern's brief doesn't address the lack of a retroactivity clause in House Bill 971, which the plaintiffs emphasize in their brief. Can you address that?
I believe that the 2023 MEPA limitation was in effect. We believe that it does take over the 2011 MEPA limitation. We believe in this case, Bitterrooters answers the question, and you don't need to get to the MEPA limitation. I expect the court will get to that in the held decision, but we don't think that you have to get there today. Thank you.
Ms. Arbine.
Good morning, Your Honors. May it please the court, Jenny Harbine on behalf of Montana Environmental Information Center and Sierra Club. The district court recognized that to most Montanans who clearly understand their fundamental right to a clean and healthful environment, the Laurel methane gas plant is a significant project. On the north bank of the Yellowstone River, the plant consists of 18 individual internal combustion engines, each with an 80-foot smokestack. And the challenge permit would allow it to operate 24/7, 365 days per year, indefinitely. DEQ's permitting action is the primary state approval for the construction and the operation of the plant, and it triggered the agency's obligation under MEPA to evaluate the project's direct, secondary, and cumulative environmental harm. I couldn't possibly cover the waterfront of all the arguments in the briefs, so I'll focus on just a couple of points related to visual impacts and noise, and then turn to the more complex issue of the need under MEPA and Montana's Constitution to evaluate the plant's greenhouse gas emissions, and on the issue of remedy. To start, the adequacy of DEQ's one-page discussion of noise and visual impacts is not a complex issue. DEQ doesn't defend its lighting analysis at all, and as explained in the briefs, the shallow discussion of both the visual lighting impacts and of noise didn't take a hard look at the severity or extent of these impacts on the human population, which is what MEPA requires. And I want to just add 2 points to the brief. And the first is that the plant's constant noise and industrial lighting adds to the harmful impacts of other industrial facilities nearby. And to hear my opponents tell it in their briefs, the fact that the plant's neighbors already are burdened by industrial impacts from projects to the west means that it should be okay, that they're facing new impacts from the plant to the north. But this is exactly the reasoning that has caused an inequitable concentration of industrial harms at zip codes across the country, and it doesn't satisfy MEPA's requirement for rational decision-making. And the second point I want to make, Mr. Langston referenced the substantial evidence standard. Plaintiffs here are not criticizing the analysis that DEQ did do. Our point is that there's analysis that DEQ omitted. And I do want to point out for the court the comments on the draft EA submitted by Mr. Lance that are attached to plaintiffs' or appellees' reply brief, which absolutely asked DEQ, plead with DEQ to evaluate the impacts on the substantial rural neighborhood south of the river, across the river from the plant. And the other point I want to highlight is the continued need for complete analysis of lighting and noise impacts. On remand, DEQ could identify measures that reduce these impacts and provide meaningful relief to families that are impacted by the plant's eventual operation. Now I'll turn to the climate impacts of the plant's greenhouse gas emissions, which, as we know, the EA didn't analyze at all.
Well, before you get to that, let me ask you. You opened with the position that this is a significant project. Northwestern filed this supplemental authority in terms of the new proposed greenhouse gas ruling, and they submit that this project would not even apply to those regulations if they're implemented. What is your response to that?
I think that's correct with respect to EPA's greenhouse gas regulations, that it doesn't impact this case, except to highlight that greenhouse gas emissions are a real problem, and there's no statutory limitation for either EPA or DEQ to evaluate those emissions either by rule, as EPA did, or on a case-by-case basis, which is clearly allowed by the Clean Air Act of Montana. Now, DEQ tried to excuse...
Well, counsel, let me interrupt you. So what about Northwestern's argument that there is no regulation?
Northwestern argues that Bitterrooters excuses the omission of a climate analysis because it claims that DEQ doesn't have this authority. I think that's just wrong based on the Clean Air Act of Montana, and Justice Baker pointed to MCA 75-2-203. That provision allows DEQ to limit emissions, quote, from any source necessary to prevent, abate, or control air pollution. And notably, this very broad authority doesn't stem from the Federal Clean Air Act or EPA regulation. On its face, it says Montana DEQ can adopt more stringent regulation than EPA requires.
So if we were to address 201 and affirm Judge Seeley's ruling and held, then what would be the next step in terms of DEQ and the regulations?
Then DEQ must evaluate the climate impacts of its decision and, under Montana's constitution, use that information to inform its decision-making over the project as a whole. And to be clear, there's no dispute about the volume of greenhouse gas emissions that the Laurel gas plant would cause. If it's permitted to operate, the plant would be one of the largest single sources in the state of Montana of greenhouse gas emissions. And the state recognized the burning of fossil fuels spur climate change and its harmful effects in Montana. And while these effects are already being felt, the incremental additions of more greenhouse gases to our atmosphere would worsen these harms. And we hardly need a better reminder of these harms than the record low snowpack in the state this past winter and the correspondingly grim forecast for the upcoming fire season. These impacts from climate change harm Montanans' health and livelihoods and threaten habitats of Montana's native wildlife. These are exactly the type of direct, secondary, and cumulative impacts that DEQ is required to analyze under MEPA. I want to turn to this Bitterrooters argument. The holding of Bitterrooters is that MEPA review is triggered when there is a reasonably close causal relationship between the triggering state action and the subject environmental effect. We've already addressed the first reason why Northwestern is wrong that the Bitterrooters holding excuses the omission of a climate analysis, and that's because DEQ absolutely has authority to regulate greenhouse gas emissions. But perhaps more fundamentally, Northwestern's argument is wrong because for MEPA purposes, it doesn't even matter whether DEQ has authority to regulate particular pollutants from the plant because it regulates the project as a whole. And all of the air pollution from the plant is the direct result of DEQ's permitting decision. This causal link is demonstrated by the EA's no action alternative. So MEPA requires the consideration of both the beneficial and adverse effects of not authorizing a project. And at AR 1172, the EA says, under the no action alternative, quote, the applicant would lack the authority to conduct the proposed activity, and any potential impacts that would result from the proposed action would not occur. So this is clearly not a case like Bitterrooters or like Public Citizen, where the action or project that causes the impacts is outside of the agency's authorities. DEQ has full regulatory authority to grant, deny, or condition the plant's construction and operation. And DEQ's air permit is the legal cause, not just the but-for cause, of all of the air pollution impacts from the plant. And I want to caution the court that accepting Northwestern's extreme view of Bitterrooters would significantly contract MEPA's scope and create irreconcilable conflicts with MEPA and DEQ regulations. And for this reason, I sympathize with Mr. Langston's request for some clarity around the scope of Bitterrooters, because this creates an impossible situation for the agency. To explain, MEPA's provisions contemplate the agency's review of impacts beyond its direct permitting authority. So for example, MEPA directs permitting agencies to consult with any state agency that has jurisdiction by law over a subject environmental effect. That's at 2011C. And this affirms that MEPA's intended review scope extends beyond the direct jurisdiction of the permitting agency. And MEPA review has to be broader than the permitting authority to meet MEPA's purpose of assisting the legislature in determining whether the existing permitting statutes are adequate or whether additional protections may be necessary to prevent environmental harm. And DEQ's rules confirm this broad scope. But ARM 17.4.609 governs the contents of environmental assessments and says they have to include consideration of values like wildlife, historical sites, aesthetics, including lighting and noise, tax revenues, social mores, and a host of other potential impacts over which DEQ has no regulatory authority under any of its permitting schemes. Also, the rules require, and again this is at 609, subparagraph 3G, that DEQ list and evaluate mitigation measures, quote, enforceable by the agency or another governmental agency, again affirming that MEPA's review scope is beyond the direct permitting authority of the action agency. Northwestern can't reconcile and hasn't even tried to reconcile Bitterrooter's interpretation, its interpretation of Bitterrooter's with the statute or DEQ's MEPA rules. And interestingly, it hasn't tried to reconcile its Bitterrooter's interpretation with its own view in this case, that DEQ properly implemented MEPA with its lighting and noise analysis, over which, of course, DEQ doesn't have direct permitting authority under the Clean Air Act of Montana. In short, Bitterrooters is no obstacle to DEQ's full consideration of the climate impacts of the Laurel gas plant's greenhouse gas emissions. And this brings me to the reason that DEQ actually gave in the EA for refusing to consider the project's climate impacts. And that was that the Montana legislature's 2011 amendment to MEPA that precluded analysis of impacts, quote, beyond Montana's borders, prohibits climate change considerations within Montana's borders. And I'll refer to this, section 2012A, as the climate limitation. The parties briefed two reasons, which MEIC pled in the alternative, for why the climate limitation didn't absolve DEQ of its duty to fully consider these impacts. The first reason, and the one adopted by the district court, is that the plain language of the 2011 MEPA climate limitation only prevented DEQ from evaluating the regional and global impacts from climate change, but it did not eliminate DEQ's obligation to evaluate the climate change impacts in Montana, and not one of the defendants offers any argument on appeal that the district court got it wrong. And appellees would request that this court affirm on that statutory interpretation ground. But if the court does not affirm the district court's statutory interpretation of the 2011 climate limitation, then the court has to go on and address the alternative constitutional basis for MEIC's challenge. And that is that the MEPA climate limitation, as interpreted by defendants to preclude any analysis of climate change impacts at all, impairs plaintiffs' constitutional right to a clean and healthful environment and does not survive strict scrutiny. The Park County case already established that Montana's constitution, as implemented by MEPA, prohibits the state from authorizing unexamined environmental harm. Park County recognized that upfront environmental analysis is an indispensable component of the statutory remedial scheme to prevent environmental harm. If DEQ's interpretation of the 2011 climate limitation were correct, Northwestern could proceed with constructing and indefinitely operating the plant without any consideration of the plant's greenhouse gas emissions, despite the environmental harm these emissions may cause in the state of Montana. And this is exactly the situation that Park County prohibited.
Ms. Harbine, Mr. Langston expressed a preference that we resolve this issue and held. What's your view of that?
It's very important to to note that this case isn't being considered in a vacuum. and that the held case, which presents a facial challenge to the 2011 and the 2023 climate limitation, is pending and fully briefed before the court. The court's concurrent consideration of this case, of these two cases, allows for a fulsome consideration of the very broad impacts and harm, constitutional infringement from the climate limitation, and the very specific practical application of that climate limitation to a single large fossil fuel project. I agree that with Mr. Langston that this court could resolve the constitutional issue in held, and it would resolve the constitutional issue in this case. I would just urge that whether the issue is resolved in this case or in held or in both, which we think is most appropriate, that it be done in a manner that prevents the infringement, the constitutional infringement that would be caused when that plant begins operating and emitting greenhouse gas emissions before those emissions have been studied by DEQ. And I'll note that Northwestern has said that it could begin operating the plant as soon as the beginning of the third quarter of this year. Finally, I'll turn to the important issue of remedy. And I want to start by talking about how we got here. The 2011 legislature adopted two alternative remedial frameworks under MEPA. The first, and the framework at issue in the Park County Environmental Council case, eliminated all remedies other than remand to agencies for an adjudicated MEPA violation. Apparently, the legislature understood the likely constitutional infirmity of eliminating nearly all remedies. And so at the same time, in 2011, it adopted alternate remedy provisions, a Plan B, if you will, which took effect after this court's Park County decision and are at issue here. But I'll explain that if defendants' interpretation of the Plan B remedy provisions were correct, they would have effectively the same unconstitutional result for MEPA litigants as the Plan A provisions that this court invalidated in Park County. And the court should resist defendants' interpretation.
Plan B, you're talking about the contingency provisions of the 2011 statute.
That's right. I can use the term contingency in lieu of Plan B. But I want to, the court should resist defendants' interpretation of the contingency remedy provisions and its constitutional implications, because the language of these remedy provisions allows for a different reading that preserves courts' ability to prevent environmentally harmful activity from occurring before MEPA review has taken place. So of course I want to start by focusing on the language of the remedy provision, section 6C, which says that it provides exclusive remedies for successful MEPA challenges. And it goes on to place conditions on remedies that enjoin a permit through a TRO, a preliminary injunction, or a permanent injunction, or other equitable relief. These are, this injunction test set out now under MEPA is more onerous than and exclusive of the injunction test in Title 27. I need to note at the outset that Section 6C is not a model of clarity. The provision begins, as I emphasized in reading the language, by stating that it provides remedies for successful MEPA challenges. But then it goes on and sets out a test for TROs and preliminary injunctions, which of course would precede any determination of success on the merits. And then the provision purports to identify exclusive remedies. But if only those remedies specifically discussed in 6C are available in MEPA cases, then the standard remedies of declaratory relief and remand, which is what I understand appellants to request here, would also be off the table. And in the legislature's 2023 amendments to MEPA, it added a separate requirement that parties seeking to vacate or nullify permits must first seek an injunction under 6C, showing the legislature's own confusion over whether vacatur was already covered by 6C and whether the remedies identified in 6C are actually exclusive. MEIC advances a statutory interpretation that makes sense of this language, and importantly, that avoids the constitutional mischief that defendants' interpretation creates. The first question for the court is whether the other equitable relief language of Section 6C necessarily includes vacatur, nullification, or other non-injunction remedies. But that term should be understood in light of the provision's express reference to remedies that enjoin activity. And as explained in the briefs, vacating or nullifying permits that have been found to be unlawful is not the same as a legal matter as an injunction. The legislature has shown that it knows how to specifically name non-injunction remedies when it wants to. So the remedy provisions that were at issue in Park County specifically referenced remedies that enjoin, void, or nullify permits. But of course, its concurrently adopted contingency provisions omitted that language. And importantly, as I noted, the legislature clearly didn't share defendants' view that the 6C injunction test applied to vacatur because the legislature added to MEPA's remedy framework a requirement now found in paragraph 6D that litigants who seek to vacate or void a permit must first obtain an injunction, again using the language that it didn't include in the contingency provisions, and showing that even the legislature understood that the other equitable relief language in 6C did not already include vacatur. Additionally, reading Section 6C to apply the souped-up injunction test to vacatur remedies raises the prospect that members of the public seeking to vindicate their rights under MEPA and Montana's Constitution would face the significant risk of injunction damages. And this case really perfectly illustrates the problem. Northwestern, before the district court, calculated the costs of a 14-month delay of constructing and operating the Laurel plant of, they said, at least $67 million. So that is the liability that plaintiffs would be taking on with an injunction at the district court level. These are the normal cost risks, although it's a high cost, they're the normal cost risks that attend to delay of project development. But the defendant's position would shift these risks from the project developer to the public, and it would shift them as a condition for the public exercising their rights under MEPA and the Constitution. Saddling the public with such bankrupting liability would make MEPA and the constitutional rights it implements practically unenforceable. Defendants offer this kind of damned if you do, damned if you don't interpretation of the exclusivity language of 6C. They say if vacatur isn't covered by the injunction test in 6C, then it must not be available at all because 6C is exclusive. But I noted that this has to be wrong because if the legislature's failure to expressly identify remedies in Section 6C means that they're not available, then standard remedies like declaratory relief and remand would also be unavailable. This absurd result can't lie.
Except aren't those remedies provided by statute and not other equitable remedies? Declaratory relief and remand?
It's true that declaratory relief is provided by statute. Remand is not, and is thought of as an equitable remedy. And importantly, remand without vacatur has been evaluated in the federal courts through this test that's identified in the Pollinator Stewardship Council, cited by the court in Park County, and does include equitable considerations to determine whether that is an appropriate remedy. But perhaps most importantly, rejecting defendants' interpretation is essential to avoiding constitutional implications. Defendants' interpretation would carry such a heavy price tag that it would make MEPA and the Constitution through MEPA practically unenforceable. On this point, I do want to point to a case that's not cited in the briefs, which is the Confederated Salish and Kootenai Tribes versus Clinch case at 1999 MT 342, where this court said, well, even if we think we know the legislature meant one thing, if that thing is unconstitutional, we will read the language if it's possible to do so in a way that avoids that constitutional problem, and we think that's exactly what the court should do here. Now, Mr. Langston requested that if the court gets to a remedy consideration, that it issue a remedy of remand without vacatur. This case demonstrates why that's such a problematic remedy, and why voiding unlawful permits is essential to preventing unconstitutional, unexamined environmental harm. And as discussed in the colloquy with appellants, initially, after the district court vacated the permit, DEQ commenced a remand analysis with some alacrity and began reevaluating its decision. I'll note that that draft EA did not evaluate or purport to evaluate greenhouse gas emissions at all because of the effect of the legislature's 2023 amendment to the MEPA climate limitation. And when the district court stayed vacatur, even though the remand remained in place, and even though DEQ decided not to defend its analysis on appeal, DEQ abandoned that process. And because the permit has remained in effect, Northwestern has proceeded with construction of its gas plant and could even begin operating as soon as this summer without full consideration of its impacts. This is the quintessential example of an airplane inspection after takeoff, the very situation this court said in Park County would offend the basic protections of the Constitution's environmental provisions. To prevent unexamined harm due to the plant's greenhouse gas emissions and visual and noise impacts on the people forced to bear the brunt of the plant's industrial presence, we request that the court vacate the construction and operation permit unless and until DEQ complies with MEPA and its constitutional obligations.
Your Honors, I first want to address the issue of relief in this case, and specifically MEIC's contention that this, if you follow DEQ and Northwestern's request, that you will end up with a souped-up injunction test that will be extremely onerous on the people of Montana. MEIC appears to be confusing the relevant provisions in MEPA. It's notable that there are two subsections in 75.1.201 that pertain to remedy. The first one is subsection 6C, which I've been referencing today, and that requires the court to make specific findings before remedy is granted. Now, they seem to be conflating that with subsection 6D, which is the bond provision, which requires individuals to post bond before a remedy should be granted. That's the only way I can get to the conclusion where they've raised that there would be some type of financial burden. And I think it's also important to focus on the differences between these two provisions. Subsection 6C says other equitable relief. That's the umbrella category of that section, whereas subsection 6D says other injunctive relief. And essentially what MEIC is requesting you to do in this case is insert other injunctive relief into subsection 6C. And the fact that they've conflated these two provisions on other matters related to financial harm suggests that they're not providing the most clarity in their arguments on this subject. I also want to address the issue of whether or not declaratory or remand relief would be available under this provision. These forms of remedy are already baked into 75.1.201, which specifically spells out when a court can find that an agency acted inappropriate under MEPA and declared that the agency didn't adequately address issues. So there's the declaratory relief, and upon the court declaring that, then the sensible thing is for the agency to correct that. I mean, that's just part and parcel with the court's declaration. Now the question is that the remedy provision gets to is, well, what do you do while that's pending? What do you do while the remand's occurring? And that's where this other equitable relief language comes into play. MEIC also brings up the language of nullify, void, the other language that was used in the 2011 version of the statute. It's the case that the legislature can use the same dissimilar words to state the same thing. I think it's clear from the legislature's intent with this nullify, void, broader language that it was really expressed that the court did not want to provide a certain remedy unless, not unless, in any instance. And in subsection C, it's saying that you can only provide a remedy unless you make certain findings. And I think that context is important to why the legislature chose those words in each instance. I want to pause here on resolving the constitutional issue in Held. And I think it's important to note to the court that, at least on the defendant side, most of the arguments relate to justiciability. And thus this court may not affirm the constitutionality of HB 971. And if that's the case, a logical outgrowth of that would be for the court to direct DEQ to apply 971 and particularly apply the exceptions that exist in 971. For instance, if the federal government designates CO2 as a regulated pollutant, then DEQ can conduct MEPA analysis. It's notable that in the district court's decision in Held and both Appellees' brief in Held, that there's very little attention given to subsection 2B. And without addressing this, I'm not sure how the court can either get to the question of its facial validity or also whether or not the statute satisfies strict scrutiny. I want to talk now about the issue of noise impacts. MEIC brought up the example of Travis Lance's comments, which is attached to its reply brief. And if you look through that comment, you can find that DEQ addressed every concern raised by Mr. Lance. For instance, he asked that the plant be installed with measures that make them suitable from a noise perspective in or near residential areas. As is explained in the EA, Northwestern implemented a number of noise mitigation measures. So that addresses Mr. Lance's comment. Additionally, he talked about the CHS refinery, which is near his house, operating on a backup generator. DEQ's EA also addresses the issue of noise impacts that might result from a backup generator. And then also he asked that DEQ address any emission limits for noise in the area, and DEQ noted in its EA that the project would not exceed OSHA limits for noise impacts in the immediate area of the project. So MEIC brings this comment up. If the court closely looks at this, it'll find that DEQ's analysis was adequately addressed all of the concerns raised by Mr. Lance. I also want to address their point that substantial evidence is not relevant here because it's not contending any, it's not questioning the conclusions arrived by DEQ, but arguing that DEQ didn't do enough. And I think that's just wrong for cumulative impacts. They're saying, we think you should have arrived at a different conclusion because this is in an industrial area and the combined effects of the existing plants should have led DEQ to come to a different conclusion. And I think it's important to note that the EA exists for the purposes of determining whether or not any impact is significant. So at the end of the road of any MEPA analysis is a conclusion on significance. And that's important to keep in mind, which is, I think, consistent with this court's analysis in Montana Trout Unlimited. Finally, MEIC complains that DEQ only provided one page of analysis on noise. That misstates the record. DEQ addressed it in multiple pages. I can at least identify 4 pages where noise was addressed, and I think that just further makes the point that MEIC is giving short shrift to DEQ's analysis, and as this court said in Waterford Flathead's Future and Montana Trout Unlimited, that it must credit the full analysis that DEQ offered in its EA. And with that, I will finish unless the court has any additional questions.
Thank you. Ms. Heim?
Thank you, Your Honor. I'd like to start off with plaintiffs introduced the idea of environmental justice, and I do not want to let that go unremarked. She talked about how Northwestern and this plant somehow are introducing an unfairness and inequity in the community. This idea is of course important, but does not exist in the law in Montana and is not briefed anywhere. Of course, if it was, there would also be all kinds of narrative about all of the things Northwestern did for this community, the trees we planted, the mitigations we did. And so that narrative that flowed through her presentation but is not briefed, I did not want to let go unremarked. I'd like to talk briefly about, Ms. Harbine talked about this plant, about the Laurel Generating Station being the biggest emitter of greenhouse gases in the state. First of all, that's not true. Second of all, it is important to note that the role of this plant is to offset renewable intermittent generation in the state when it is not available. It is critical that this plant be available because it, one, is available when nothing else is, and when we need it, it offsets other things that we buy in the market that often is much, much dirtier. This plant for thermal generation, it's brand new. It has best of class technology, and it is remarkably clean for thermal generation, and that is often lost in this debate. Ms. Harbine talked about 17.4.609, which is a laundry list of considerations that DEQ may take into consideration: wildlife, aesthetics, other issues like that. Of course, DEQ can take those things into consideration, but they have no regulatory authority anchored to a substantive statute by which they can condition or deny a permit on that basis. That is critical, because Bitterrooters tells you that MEPA cannot overtake that substantive statute without that anchor. And at the end of the day, that is what the case is about.
Well, so let me just, sorry.
No, go ahead.
If DEQ had not looked at all at impacts on wildlife or impacts on noise and lighting and any of that, could the plaintiffs bring a MEPA challenge?
I think that they could have raised a MEPA challenge, but they certainly could not have asked for vacatur. They could not have asked for the permit to have been denied or conditioned or modified in any way. So at the end of the day, when we're talking about what is the role of MEPA versus what is the role of the substantive statute, you have to keep those two things in mind. And so one of the items that Ms. Harbine talked about was the issue of lighting and noise, and our failure to reconcile noise and light with our challenge of greenhouse gas. To be frank, at the end of the day, noise and light are issues that DEQ often looks at. We thought that they did an adequate job in the EA. We were fine with it, and they did not condition the permit on those items, and we did not think it was worth arguing about. It just wasn't part of the discussion. We are a regulated utility, and we often work with our regulator on these types of issues. There is always give and take. At the end of the day, we get to the bottom line. We get to what is best for us, best for the grid. It's always about balance. What do we have to do to provide reliable, sustainable, affordable energy for our customers and for Montana? I do want to, on this point, I do want to look at Bitterrooters in particular.
Well, before you jump to that, so essentially, you're saying that in MEPA, they could consider greenhouse gases, but you certainly can't tie the vacator of a permit to that.
Well,
I mean, if you can consider all this other stuff.
In our view, they could have, they chose not to. So in this case, the case is closed. the MEPA limitation was in effect, and so they chose not to. They identified it appropriately, so they fulfilled all of their obligations in the EA related to greenhouse gas. Going forward, and at the next permit, for the next company they look at, whatever the next application is, they certainly could make a different decision. We think that the case is closed for this particular application.
But if they did that, you're still saying that they can't get a modification or change anything or make any decision based on their considerations, so why would they do that?
I absolutely agree. Under MEPA, you can't condition or deny a permit based on that. You have to have a regulatory basis grounded in the substantive statute, consistent with other pollutants regulated under the Montana Clean Air Act. And so that really does get to what is the plaintiff's quarrel. It's not with the DEQ's analysis under MEPA of greenhouse gas emissions. Their quarrel is with the legislature and whether or not the legislature has directed DEQ to actually regulate greenhouse gases. That's not a
Well, no, they're advocating that the perspective on MEPA is broader than the regulatory statutes.
And their argument, I think their argument is, and what Bitterrooter says, is that MEPA is to inform. It informs stakeholders, it informs the legislature of what is the gap in the regulatory analysis. But what plaintiffs want you to do is then require DEQ to fill the gap. But that makes MEPA into the substantive statute. And that's what Bitterrooters tells you should not happen, because then you are making law at the same time that you are trying to apply the law, and that's what is not supposed to happen.
So if the court would have determined that the lighting analysis was not sufficient or noise considerations were not sufficient, I assume you would be here arguing that, well, they don't have authority to regulate light pollution or noise pollution anyway.
Well, I would first argue that DEQ's analysis was absolutely sufficient on the basis of lighting, because they did look at all of the considerations that the court laid out in Belk: distance, scope, geographic scope, frequency, duration, all of that good stuff. But I also think that we as the regulated utility would have mitigated at the time, and we work with our regulated utility. We could absolutely make the argument that it's outside the scope to deny our permit on the basis of lighting. Yes. I do want to briefly talk about the remand issue. Remand with vacatur slaps Bitterrooters, and because it elevates MEPA over the substantive statute. You know, the bonding issue that Ms. Harbine talks about, I believe is a red herring for the reasons that Mr. Langston discussed. She talks about all of the harm to the public by doing a bonding, but that ignores the harm to the utility and the underlying issue of what is the project, what is the purpose. And for us, our purpose is to serve Montana. This project serves Montana, and ultimately we ask the court to overturn the district court and reinstate our air permit. Thank you very much.
That concludes the argument in this matter. Thank you to all counsel. I would note that, as you probably noticed, Justice Standifer is not available today. He will be reviewing the record of the argument and is participating in this case. Thank you very much.